NACDL is the association of the nation's criminal defense bar.
I'm Jumana Musa. I'm the director of the Fourth Amendment Center here at NACDL. We are thrilled to have you with us today for our webinar on Search, Seize, and Extract, which is looking at the use of mobile device forensic tools and technologies in criminal cases. So essentially what we're talking about today is the answer to the government's often complaint that encryption is somehow keeping them from solving crimes, that people are going dark, so to speak, with these encrypted devices, and that if we don't have companies put backdoors into everybody's digital device, they'll never be able to solve crime again. Well, Upturn did a report where they FOIA'd law enforcement agencies across the country, and what they found is, well, we all know that's not true. They, in fact, have many tools to get into mobile devices, and they use them frequently. And they use them in all aspects of crime, right? Not the most serious crimes, not what they'll tell you like, well, we have terrorists on the loose, but they use them for anything and everything. And so today we're going to take a look at how pervasive the use of those tools are. What do those tools do? How do we think about those tools and situate them in the context of constitutional law? And how do you challenge them when you get to court? And for this, we are actually joined by an all-star faculty. I'm not going to go deep in the introductions because you got them all when you registered, but we're going to start with a brief intro from Jerome Greco, who's a public defender in the Digital Forensics Unit of the Legal Aid Society in New York, and deeply expert in all things extraction. We're also going to hear from Harlan Yu, who is the executive director of Upturn, which is a really a technology and social justice organization that often looks at the intersection of technology and whether it's a criminal legal system or other systems, the constitutional implications and the rights of people. Who's going to walk us through some of what they found in their extensive report, which I believe is also in your materials. And then we're going to hear from Jennifer Granick, who is a surveillance and cybersecurity counsel with the ACLU Private Speech Privacy and Technology Project. I don't know why I always want to make it privacy speech, but it's the Speech Privacy and Technology Project, who has also been deeply immersed in these issues, even long before she was at the ACLU. It's going to walk us through some of the constitutional aspects of it and also the trends we're seeing. And we're going to actually go back to Jerome to wrap up to talk about legal challenges. So again, with my apologies for starting a bit late, we're thrilled to have you all on. We are going to do Q&A. That will be, of course, after we hear from the speakers. So if you have questions, please put them in the Q&A. I will get to them at the end. I will be asking them of our panelists, so they're not trying to go back and forth and toggle and answer you. So just be a little patient with that. We will also be putting up the code for your CLE credit. We will do that after the presentations before Q&A, and we'll do it again at the end. So hopefully that works for everybody. I am really, actually myself, excited to hear from our guests. So I'm going to turn it over to Jerome so we can get started.
Thank you, Joanna. I'm happy I could join here and be working with Harlan and Jennifer. So it's great. I'm going to share my screen so you can see my slides. So I want to give everybody a kind of a little bit of introduction to technology, some of the technology itself. And as Jumana said, I'll then pass out to Harlan and Jennifer and come back to me at the end. So there are many different mobile digital forensic tools and companies that create them. There are a few that are probably more well known than others. Celebrate Magnet probably being the cream of the crop, so to speak, and often the most commonly seen. And I'm going to talk a little bit about both of them to start off. But first, the question I always get is, what is an extraction? What exactly are you talking about here? So an extraction really could be, it's kind of has two things, right? Extraction is the actual process of copying the data off a device, in theory, in a forensically sound way. And also it's the file or files that result from this process. Sometimes it's similar to what you would hear called an image. Usually when people were talking about more old school or standard hard drives and laptops, one of the reasons why I try to avoid the word image is that image generally means that it's a bit by bit copy, meaning it's getting everything possible, including anything that's been deleted but still recoverable. Where in extraction, that's not always true. And there are a lot of different types of extractions, which I'm not going to get into right now, and different companies call them by different names. But suffice it to say that depending on the model of phone, the operating system, the tool that you're using, and some of the settings will really depend on how much data you can get off and how reliable it would be. I also want to point out the difference between an extraction and a report. So reports are being made from the extraction, right? And it's usually somebody who, in theory, is an expert and can do that. But it's not giving you all the data that you would get in extraction. The benefit to somebody who is not an expert or doesn't have access to the tools, the very expensive tools, is that a report by most companies, there's a version that could be opened and reviewed without having licenses to those expensive tools. The downside, of course, it doesn't come with all of the data that an extraction comes with. And also, in theory, it allows the person making the report to choose what goes into the report. And you may not always be able to see that something has been kept out. And of course, I never want to be in a position where I'm relying on law enforcement or the prosecutor to tell me that they've given me everything in the report, that there's nothing missing, because I've been proven wrong many a time. Celebrate and Magnet, again, are the two like big players in this field. Celebrate's line is usually their UFED Touch 2, which you can see a picture of here, which is actually a standalone device that's used to extract data and copy data. The UFED 4PC, which is the software that you can actually run on a computer in order to do virtually the same thing that the Touch 2 does. And then Physical Analyzer is the program that basically analyzes this data. Magnet's main suite is called Axiom. And Axiom is basically similar to Celebrate's UFED 4PC. It's not doesn't come on a standalone device. It runs on a computer, but it also runs in a very similar fashion. And as I'll talk about very shortly, Magnet has actually partnered with a company called Grayshift to provide a product called Graykey. Before I do that, I just wanted to give you a quick look at what a screenshot of what an extraction report, what we call a UFED reader report from Celebrate looks like. And you can see that on the column on the left-hand side, there's all these different types of data that's broken down that are parsed out. And so you could open up to say, okay, I only want to look at my emails that were pulled off, or I only want to look at the images that were pulled off. And this ability, one, it makes it a lot easier to go through the data for yourself and also for the person who did it. But it also makes it possible that law enforcement doesn't have to look at everything like they claim, right? And so if they have probable cause to look at just the images, then it's really hard for them to justify them looking at the call logs, right? Or vice versa, especially when it is parsed out like this. There may be unusual circumstances, but for the most part, that's the truth. Celebrate Advanced Services and Premium. So Premium is basically just advanced services in-house. Advanced services means you have to send it off to them. Premium is that law enforcement only ability to have it in-house in the precinct or their office with similar capabilities. What this is that it's basically able to get into phones that are not, that commercial available software and hardware can't get into, right? So like a brand new iPhone, a brand new Samsung Galaxy phone, it's able to get around those locks or to break the lock. Similarly, as I mentioned before, there's a product called Graykey, which is made by a company called Grayshift, although they have now partnered with Magnet Forensics. And that is also a product that's law enforcement only, and it's available, again, that they can have it in-house. And similarly, at least at one point, Graykey only worked for iPhones. It was only breaking into iPhones, but they recently expanded to Android devices. And so, these products aren't cheap, but as I'm sure Harlan will explain, that they're more readily available to law enforcement than I think people were aware of before. With that, I am going to turn it over to Harlan.
Hey, everyone. My name's Harlan Yu. I'm the executive director of Upturn, which is a technology and justice nonprofit based in Washington, D.C. So I'm going to be talking today about a research and advocacy report that my colleagues and I published last fall called Mass Extraction, which examines how law enforcement agencies across the country have been using the forensics tools that Jerome just talked about. But first, maybe just a little bit of context. So over the past few years, we've seen significant public attention on a number of high-profile cases involving potential evidence on mobile phones, especially in cases, as Jumana was talking about, where law enforcement has claimed that it can't access data due to encryption. Many of you probably remember the dispute in 2016 after the San Bernardino shooting between the FBI and Apple, where the FBI tried to get Apple to help it break into a locked iPhone, which Apple refused to do. But regardless, the FBI ultimately found a way into the phone without Apple's assistance. Later in 2019, similar issues were raised again after a deadly shooting at the Naval Air Station in Pensacola. And just repeatedly over the years, the DOJ and the FBI have been seeking ways to more easily circumvent encryption and other security protections on digital devices and communications. And, at least in their telling and their framing, law enforcement says it's going dark because of encryption. And so they're seeking so-called exceptional access to encrypted phones, presumably in these rare high-profile cases that involve suspected terrorism or child exploitation or other crimes that have major harm. But in our recent research, we paint quite a different story about what's happening, especially at the local and state levels, about how law enforcement are gathering tremendous amounts of sensitive data off people's phones. So starting in 2019, my colleagues and I spent nearly 2 years gathering as much data as we could about how law enforcement agencies around the country are already today gaining easy, routine, and widespread access to data stored on people's cell phones and other digital devices using the kinds of mobile device forensics tools that Jerome talked about. So to do this research, we sent more than 110 public records requests, FOIA requests, to a range of major police departments, sheriff's offices, district attorneys, and so on, asking them to disclose purchase records so we could understand what tools they have at their disposal. We asked for records of use so we could understand how often they're using these tools and in what kinds of cases, and any policies that describe any guidelines or safeguards they have in the use of these tools. We also poured through numerous government spending websites and grant databases to piece together this information. And we also studied the technical capabilities of these tools by looking at vendor information. And Jerome and his team at Legal Aid also graciously invited us to his office before the pandemic to get our hands on these tools as well. And so here's what we found out. One of our main findings is that every American is at risk of having their phone forensically searched by law enforcement. In our research, we were able to document at least 2,000 law enforcement agencies across the United States that have purchased a range of MDFT products and services in all 50 states and the District of Columbia. So here is a map of the major police departments, right? And so every one of the 50 largest police agencies in the country have access to these tools, including state law enforcement agencies in all 50 states. And here is a map of all 2,000 agencies that we've documented. And so you can see all the red dots scattered all across the country. And I should add that, this is almost certainly an undercount, right? These are only the agencies and jurisdictions we were able to document as having these tools. And we imagine there must be many others that are harder to document that didn't surface in our research. I think one thing that really surprised us was that these tools are even available and have been purchased by some pretty small departments, right? Jerome just said that these tools aren't cheap, but they're at least cheap enough that even small departments like Shaker Heights Police Department in Ohio or Walla Walla Police Department in Washington, Lompoc Police in California, and other departments that have just a couple dozen officers all have access to these forensics tools. I should also point out too that there's actually there's often a lot of interagency sharing of these tools, where the larger departments who are more resourced will have access to these forensics tools that they share with smaller nearby departments that then tap into the use of these tools as well. On the federal level, the FBI also has a program for regional computer forensics laboratories, or RCFLs. And what these are 17 locations across the country that have these forensic kiosks and these tools available for use. So if you're a police officer that doesn't have one within your own department, these officers can access these tools by driving to these kiosk locations to perform cell phone extractions. So these tools are pretty widely available. And so now let's just talk about how these tools are actually being used by the departments who have them. So another main finding of our research is that MDFTs are a pervasive tool for even the most common offenses, right? They're being used not only for high-profile terrorism cases and child sexual exploitation cases, but also for graffiti, shoplifting, marijuana possession, prostitution, vandalism, traffic crashes, parole violations, petty theft, public intoxication, and the full gamut of drug-related offenses. Overall, our research shows that law enforcement agencies have performed hundreds of thousands of cell phone extractions since 2015, which is far more than I think anyone had previously documented. So we're able to glean this information through the records of use that we received from various agencies. And here are a few examples of logs that we received from different departments. And as you can see, there's actually a lot of variation in the way that different departments maintain their records. Some departments record the crime type or type of case or offense that the phone extraction is related to. Others have the specific model of the phone. Some show the legal authority. And when there is legal authority, sometimes they have the warrant number. And some departments don't even maintain logs like this at all, right? We filed our FOIA request and they said, well, we don't keep that because, and they don't even know how many device extractions they do because all of that is stored within individual case files. So there's no standard across the country for how this information needs to be kept. But looking at the big picture, based on all of the records of use that we received from all the agencies, we were able to at least sketch out the basic story, which is that many law enforcement agencies use mobile device forensic tools as an all-purpose investigative tool for an astonishingly broad array of offenses. And their use is definitely growing over time. You'll notice too that, for example, on the bottom right here, that officers often aren't getting warrants to perform these searches. Now, they're required to get a warrant under the 2014 Supreme Court decision in Riley v. California. But in many cases, exceptions to the warrant requirement, particularly consent, is actually a pretty common practice. So for example, in Harris County, the sheriff's office there in Texas disclosed that between 2015 and 2019, over a 4-year period, only 47% of the phones that they searched and extracted were subject to a search warrant, which means that the other 53%, the majority, were actually consent searches or searches of phones that were deemed abandoned or from somebody who was deceased. Similarly, about half the cell phone searches performed by the Denver Police Department in 2018 and 2019 were based on a warrant. And so the other half was based on consent or other exceptions to the Fourth Amendment. And about a third of the phones, cell phone searches by the Seattle Police Department were also based on consent. So this was definitely a trend that we noticed across the country. And of course, when there's no warrant, this means that the searches are not subject to their constraints. And not to say that warrants actually provide many constraints in reality with overbroad warrants, which we'll talk about later in this webinar, but using consent, a lot of these departments are able to skirt around a legal process. So let's talk further about constraints, or really the lack thereof. One thing that we asked for in our public records requests were policies. Many departments responded to our requests by saying that they don't have any specific policies in place regarding how officers and investigators use these tools. And for those who did, fewer than 10 departments had policies that we would describe as meaningful and specific. Most departments, when they did have policies, only had generic search and seizure guidance or guidance about Riley and the need for search warrants, but very little else in the way of specific policies that limit the scope of searches, that limit the amount of time that data can be retained, whether data needs to be deleted, and so on. And so the overall upshot is that we're seeing the growing use of MDFTs, and it's a dangerous expansion of law enforcement's investigatory power. And just to underscore again what Jerome was talking about in terms of how invasive these tools actually are, right? When there's an extraction, these tools oftentimes give law enforcement access to all of the data that's stored on somebody's cell phone, right? So that's all of somebody's emails, text messages, photos, contacts, location history, call logs, web browsing history, data from all of their apps, sometimes even deleted data, and more, right? This is like everything on your phone. One commentator called these kinds of phone searches, especially for modern cell phones with all of the information on it, a window into the soul. And of course, this matters not only to the owner of the phone, but all of their friends and family who they've been in contact with using that phone. At a systemic level, given how routine these searches are today, and given law enforcement's history of racist and discriminatory policing practices, it's more than likely that these technologies disparately affect and are used against communities of color. So ultimately, we don't believe that these tools should be used, but short of that, our report provides a few concrete recommendations, which I'll briefly describe. Okay. So our first recommendation is to ban the use of consent searches of mobile devices. Because as I'm sure many of you well know, consent searches are a legal fiction, and there's inherent coercion in any search involving law enforcement. The venue for this recommendation would likely be legislative. And just as an example, just last month here in DC, where I am, the DC Police Reform Commission made a recommendation to DC Council that they prohibit all consent searches, not just for mobile phones, but as a blanket prohibition across the board. And so if the DC Council decides to take up this recommendation, as far as I know, it would be the first full ban on consent searches anywhere in the country. Our second recommendation is to abolish the plain view exception for digital searches. So for physical searches, the plain view exception allows law enforcement to seize evidence in plain view of any place that they are lawfully permitted to be, especially if the incriminating character of the evidence is immediately apparent. But for digital searches, this standard makes no sense. The idea that digital evidence can exist in plain view in the way that physical evidence can, when considering how software can display and sort overseas data, in our opinion, is just incoherent. Our third recommendation is to require law enforcement to maintain an audit log for every search that details the precise steps that law enforcement took when extracting and examining a phone. So this functionality doesn't exist yet in existing MDFT tools, but it's something that vendors could pretty easily build into their software, right? As Jerome was showing you, examiners will see an interface with all of the data categories on the left-hand side, where an investigator essentially browses through all of the data on somebody's phone. So for example, you could imagine a vendor building in automatic screen reading technology that records what an examiner does. And this would allow a judge or a defense lawyer to later essentially play back and understand how the search was actually conducted, and to give defense lawyers a better chance at suppressing overseas information. Our fourth recommendation is to require law enforcement agencies to delete any extracted cell phone data that's not related to the objective of the warrant, and then to seal or even delete extracted data at the conclusion of a case. And the idea here is to limit law enforcement's ability to repurpose somebody's phone data for a later unrelated investigation, which is something that we've seen in some cases, and to limit how this information might be later incorporated into general purpose investigative databases like so-called gang databases or perhaps even predictive policing tools. And last, we believe that law enforcement agencies should also be required to publicly log the usage of MDFTs, basically the logs that I showed you. So there would actually be real data and a clear narrative about how law enforcement actually uses these tools today in practice, which I think would prompt better policy and advocacy in response. And so I'll stop there for now. there's the report. The report's also in your materials. You can also access it online at that URL. And if you have any questions, I would love to also hear from you via email, and that's my email address. And I'll pass things over to Jennifer.
Thanks, everybody. And thank you for having me and for organizing this. At the ACLU, I work for the Speech Privacy and Technology Project. And much of our work involves trying to obtain Fourth Amendment protections for different types of data that are generated by new technologies. And those Fourth Amendment protections we argue for would require a warrant. But another giant part of our work that we've been focusing on lately is about warrants and making warrants mean something, making them strong, because having a Fourth Amendment warrant requirement doesn't help that much in protecting people's rights if the warrants are then, just basically routine to get or easy to obtain. So we've been focusing on this issue of exactly how electronic data is seized and searched and how to constrain those searches. And this issue of the use of forensic tools on electronic data is a really challenging one because of the very nature of how electronic data comes to police from either computers or from mobile devices. The inherent nature of these devices and of electronic data is that information that may be responsive to probable cause, that may be evidence of the crime under investigation, is inherently intermingled with information that is not about the crime, that is about people's everyday lives, that is the window to the soul, that is revealing not only about the person who owns the phone or the computer, but also about the people they communicate with. And it reveals intimacies of those people's private lives as well. In the real world, we have some inherent sense about how searches can be conducted. You can look in a particular place where the information might be, but you can't look in a place where it can't. But in digital context, all the information is together. So how do you conduct those searches or seizures? And the courts have generally taken the approach that over seizure of data is acceptable, even though that means that far more information ends up in the hands of law enforcement than is responsible to probable cause. And that's justified on the grounds of just basically administrative convenience, that there's no way to do a meaningful segregation or search of relevant information from irrelevant information at the point of seizure. So the hardware and all the data on it, it's okay for police to take. And then the search has to take place later on. This is an assumption about how data searches should happen. And it's not always going to be true that over seizure is reasonable, that it makes sense, particularly in the context where sorting can happen prior to disclosure of information to law enforcement, such as with a social media account. But it does make sense that with hardware seizures, such as phones or computer hard drives or laptops, the police are going to end up with this whole bunch of information. And then the question that courts have been struggling with, and the question that we struggle with, is how to make sure that those, that those seizures don't end up being a bonanza of information for the police to, basically take advantage of, to rifle through, to be able to do suspicionless searches, to obtain information they're not entitled to. And I think that there are kind of two approaches there, which is to limit police access to and search of the data to the extent possible, and to limit uses of the non-responsive data. And when talking about how to limit police use of or access to the data, these forensics tools that we've been talking about can be both, I think, a blessing and a curse. Because as Harlan pointed out, far more information, the information that these tools produce, that these tools reveal to law enforcement, is far more invasive than a manual search of the device would be, because the tool is able to extract substantially more data and expose that to police. So the question is, in the functionality of these tools, how does it map onto the Fourth Amendment justification for the search? And that's the grounds for challenging the use of these tools from a constitutional perspective. In a warrant, there must be the search must adhere to the probable cause that's established in the warrant to believe that the items searched and seized are going to contain evidence of the crime. So how does the tool that's being used on your client's data work, and what is it doing? Is it extracting too much data? Is it putting too much information in the report for police to be able to view it. So we know that probable cause can be limited by time frame. Probable cause can be limited by type of data, images versus documents, text messages, not between the suspect and everybody, but between the suspect and the identified co-conspirators. Categories of data. If the tool is basically extracting all the data from the phone and then revealing that data for police and allowing police to search it without making these limitations, it's no longer an administrative convenience that's required in order to do the segregation. The segregation is happening with the tool, and it is not being done, and the segregation is not taking place in a way that's consistent with the probable cause of the warrant. So that's taking out too much information and exposing it to the police. I want to take a moment to talk about consent searches. For me, this was one of the things in the Upturn report that Harlan worked on, which was so surprising, is how often consent is a justification for searches of cell phones, which is just so interesting when you think about it. After the Riley case, it's not going to be search incident to arrest. Of course, police are going to turn to another technique, and that technique is trying to obtain some kind of consent. So that's caused us to take a closer look at consent searches in the context of cell phones and think about what does consent really mean? We know that consent is a legal fiction in the regular run-of-the-mill cases, but I think that's particularly so in the context of cell phones. We filed an amicus brief in one case, the Birch case in Wisconsin, which involved a person who consented to the police reviewing his text messages in order to show that he was talking to a certain person at a particular point in time. And what the officers did was they took his phone, they got him to sign a form, and they took the phone away and did a full forensic download of all of the information on the phone. They then retained that information on the phone for a while, and then later on searched it for evidence of an entirely different crime, a murder. One piece of that case is the question of whether using the forensic tool in order to do this download was consistent with consent. What does consent mean? And we argued in that case, and the Wisconsin Supreme Court seemed very receptive to the argument that consent has to be like a person's common sense understanding. It's not a forensic tool, comprehensive download of everything, even when there's a form, just a kind of rote form that a person signs. It means what a normal person would understand, which is something consistent with a police officer or a friend scrolling through the text messages. And the court did not seem receptive to the argument that this forensic download was required in order to affect the consent search. It went too far. So I think we can look closely at both the terms of the warrant, if a warrant is there, in terms of what are the actual categories of data or the time frame or the relevant people who are involved. Or in the context of consent, what is the actual scope of consent in the average person's reasonable understanding of the situation, even where there might be some kind of legalistic form signed. What would the normal person in their course of their life think, and see whether the device was used to obtain data as it's designed to obtain data far beyond that scope, or whether it was used really to just narrowly seize that or narrowly surface that particular piece of information. So that's the question of whether the device took more material than the police were entitled to have, or exposed for examination more material than investigators were entitled to look at. The second constitutional issue, I think, is how the search was conducted. And as I mentioned, the tool is far more invasive than a manual search because it extracts so much information. And as we've seen, they aggregate all the files found on the device and enable a kind of data analysis that is far different from what you could do on a manual basis, which it risks exposing even more personal information to police than you would imagine in a normal, just like physical examination of the phone. I'm not sure that that on its own is a reason to challenge these use of these devices from a constitutional perspective. The law does say that the police can use binoculars and lights, for example, without that necessarily being a greater invasion of the expectation of privacy. But it is a question, this is already a search. It's not a question of whether using binoculars creates something, makes something into a search. The question is the search a reasonable one? And that is inherently has to be limited by the justification for the search, whether it be consent or probable cause. I think that there is a way to leverage the use or the existence of these tools in a manner that might be helpful, and to sort of have the fact that these tools exist be an argument against some of the more expansive searches that we are seeing happening. So kind of as a baseline, there are a number of cases, including the Ninth Circuit's case, comprehensive drug testing, which is one of the most extensive explorations of the problem of searching intermingled data, electronic data in a constitutional fashion, and including the Fourth Circuit's case, United States versus Williams from back in 2010, in which the courts have assumed that investigators need to be able to examine every file on the phone. And the idea is that because the data is intermingled, because it's possible for sophisticated users to hide the true nature of the information and mislabel files and do other kinds of surreptitious things to mask evidence, that the investigators really have no choice but to go through everything. And that is both crazy because there is no way that any investigator can ever go through anything. There's always just going to be some sort of random rummaging and guessing in that process, which is exactly what the Fourth Amendment's warrant requirement is required and designed to prohibit, that generalized rummaging. It's not worth the time. The investigator is basically going to be looking in places where there is no reason to look. But it also means that if you can examine lawfully every file, that a warrant, which has to be particularized and have probable cause to a particular crime and particular evidence, essentially ends up being a general warrant authorizing generalized rummaging through everything on a device in every single case. So it's neither good for it's neither good for the police in that it doesn't help target the immense amount of there's too much time and energy that would be required, far more than any human could ever do, to look at all the files on the phone. It enables this general rummaging, and it ends up basically subverting the law enforcement's ability to find evidence. So if we don't want every warrant to be a general warrant, we don't want to depend on law enforcement rummaging to be, a way to actually get evidence in cases. What are the alternatives? And it seems to me like the existence of these tools, where properly regulated and constrained, can be one of these limitations. The existence of these tools means that the supposition in comprehensive drug testing and the 10th Circuit's holding in the Williams case are wrong. Police don't need to aren't justified in just randomly opening files. They need to be able to use the tools that are out there in order to constrain their searches by time, by type of file, by people involved in the conversation, and whatever other kinds of limitations are possible. Depending upon what the probable cause is. And that courts can help check and enforce these limitations by using the functionality on device forensic tools to generate query logs, or requiring police to keep query logs so we know what the searches were and we know what information was turned up. These can be limitations that magistrates perhaps should implement prior to issuing the warrant, or can require query logs after as part of the subsequent review of the propriety of the search, as the magistrate exercises the judicial oversight function and as part of a motion to suppress or defense attorney challenge. And all of this information should be discoverable and disclosed to attorneys, and can also impose limitations on retention and that sort of thing. And I'll just mention very quickly that we have a number of cases where that we filed amicus briefs in, where police have seized cell phone or computer data based on one justification, a warrant, or in the Birch case, consent. They've held on to that information for some period of time and then subsequently searched it for evidence of a different crime or different crimes later on. And they've been able to do that because these tools, these forensic tools, extract all the data, and it's very cheap to hold on to it. And there have not been rules or obligations about deletion of the data after cases are over or after a certain period of time or that sort of thing. People may be aware of the Second Circuit case, Ganias, where this is what happened. The data that was seized in an investigation was retained for a couple of years, and then the investigators, FBI, went and got a second warrant and searched it again. What we're seeing repeatedly in these state courts is there's no second warrant happening. There's just a subsequent search. And we're very interested in these cases. We filed amicus briefs in a couple of state Supreme Courts in these, basically fighting against police arguments or state arguments that once the data is seized, there's no more expectation of privacy in the data, so they can search it for whatever they want, whenever they want afterwards, which is basically make the general search or the general warrant argument saying, of course, it doesn't matter if it's a general warrant. Every warrant, once it's executed, means you can do whatever you want with the data afterwards. Justifications based on plain view, which are, basically, Harlan talked about it, but there are also some arguments that we've made that there should be use restrictions imposed on police use of all non-responsive data because, to avoid the bonanza effect of having access to all this other information that you ordinarily would not have been able to seize in the first place because there's no probable cause. In order to protect the privacy, not just of the person whose data is on the phone, but of the other people with whom the owner communicates with. So I think that these tools pose real challenges because of their the power, because they make it much easier to obtain and to retain and to search data. It makes searches much more. There's a lot more. It reduces the costs to conducting these searches. But I do think that we are going to see forensic tools used in cases. And when they are used, there are strong arguments that they can, not only that they should be used in ways that are properly constrained by warrants or by the scope of consent, but also that the tools provide functionality that can move us away from some of the earlier cases suggesting that electronic search warrants are essentially free-for-all rummaging through data. These tools mean that electronic search warrants can be executed in a more narrowly tailored way and enable oversight by both the court and challenges by defense attorneys through logging. And with that, I will pass it back to Jerome.
So there's your CLE verification code. It is 7H7432. Please write it down, capture it somewhere, because you will need this if you want credit. 7H, like Harry, 7432. So again, please write it down because you can't get your credit without it. We will also be putting it back up at the end of the webinar, so you will see it again.
So actually, before we go into Brian Dower challenges, I want to just build off a little bit what Harlan and Jennifer were talking about in terms of the technology being able to limit essentially this free-for-all that the courts have, a lot of the courts have seemed to have accepted or have permitted. And one, there are a lot of ability to do that right now in the tools, and it's always interesting to me because it's sometimes an argument I have with even my own in-house analysts and examiners is that the way they're trained is to pull everything and that anything can be hidden anywhere. And while, yeah, that's in theory possible, it's not probable cause to look everywhere. And it's also unrealistic in the vast majority of cases that people are sophisticated enough, especially on phones, because it's actually more difficult on phones to hide stuff than it actually is on a computer. or to intentionally label something incorrectly. But so they get this training to do it that way. And then the tools themselves, the companies don't have a lot of incentive right now to build out the things that they currently say they can't do, right? And so you'll get, well, we can't do this. And it's like, well, it's because nobody is forcing you to do it. As soon as a court start issuing binding decisions that require them to do certain things, I guarantee you all of that research money that is going to other things that they're doing will go to find a way to do what the court needs them to do so they can continue to have their product be useful. And we've already seen that to some extent with some of the tools, for example, Celebrate on some phones, right? When you do the initial extraction, you can choose a date range. You can choose types of data that you want to pull off. You don't have to pull off everything. Again, this isn't for every phone and every iOS, or every OS, but it does exist for some of the products. And I bet if courts started saying, well, this has to exist, they would find a way to do it, just as they have every time there's been something that would prevent them from making money and having their product be useful. With that, I kind of want to, transfer over from the motion to controver aspect of it, although there is an example provided in the materials. But also, this has come up a lot recently, and I'll talk about why, but Fry and Daubert challenges to these tools. And, just as a reminder, here's the Fry Daubert standards, just to give everybody a quick reminder. But the reason why this has come up recently, or I'm being asked about it a lot recently, is because of Signal fight with Celebrate. And for those of you who are unaware, essentially what happened was Celebrate published a blog post, which they claim was not supposed to be published, that it was a draft with incorrect information. They eventually took it down. But in that post, it had claimed that they were able to break Signal's encryption, or they were able to seize data from Signal. What wasn't clear, and if you don't know better, it made it seem that it could seize, intercept, essentially, and break messages that have been intercepted. So for those who don't know, Signal is mainly a messaging app. It's an encrypted messaging app. I'm a big fan of it personally and encourage people to use it. And so when something's being sent from one phone to another, it's encrypted. So if somebody was to intercept the message, they wouldn't be able to access the actual content without one of the keys, without the key, right? And Celebrate's blog post kind of indicated that they were able to do that, which was not true. What they really were able to do is that if they had your phone in hand, and were able to get into the phone, they were able to get into the Signal database on the phone, which is a lot less impressive. But you can imagine a lot of privacy conscious people use Signal, and when this blog post came out, Signal got a lot of heat, and they were very unhappy because things were not true. And so just recently, Signal main owner or founder, Moxie, claimed to have found Celebrate tools that fell off a truck. God knows where he got it, but and they did their own analysis of Celebrate's tools to try to find flaw in them to exploit, and they were successful. And they posted it publicly on their blog, and you can see the link there. And they did a proof of concept. So essentially, they were able to show that they could put a file on the phone that would disrupt the reporting capabilities of Celebrate's UFED4PC product, but not only for the report for that phone or that extraction, but for future ones, or reports on prior extractions that have been done. And you can see here, one of the ways they showed this was they actually had exploited a pop-up message. And for those of you unaware, that's a reference to a classic hacker movie called Hackers from 1995. It's a reference to that. And their whole video is actually mainly references to hackers. But what does this mean for everyone else, right? So the questions I'm getting is, well, can't we now challenge everything Celebrate's ever done? And the answer is yes, but as smoking gun as I think people thought it was or think it is. I do know I saw there was an article that came out later that I think an attorney in Maryland was challenging it. And while I do encourage people to cite this in a Frye or Daubert challenge, the problem I'm going to run into here is that Signal, at least the flaw that they say they've exploited or were able to show, seemingly didn't affect the underlying data itself. So the reporting tool, right, that Celebrate is using it could give a bad report, but the underlying data that it's reporting on is seemingly unaffected, at least by this flaw. What that means is that if you run that same data, right, that same extraction through another program, you're not going to run into this issue because this was a flaw unique to Celebrate's particular reporting software or parsing software. And so an easy way for a law enforcement agency to prove that they don't have this issue is to run the extraction through more than one type of forensic program. So you could run it through Celebrate and get your normal report, and then you could run it through Magnet, and then you can compare them and see if there's differences, right? Obviously, that's more work, and I'm sure there's plenty of law enforcement agencies that are not going to do that, but it is possible. The other part of this is you could also just use another tool. So I do think that this is something people can fight about, but I don't think it's as juicy as some of us may have hoped. And for their part, Celebrate has claimed to have patched the flaw. Obviously, I even though we have the tools ourselves, I don't exactly know what files Signal was using, and so it's a little hard for me to test how accurate that is, but that's the claim at least. With that, I often get this question too about experts, and it's interesting to me because there are a lot of these law enforcement agencies that are spending a lot of money on these tools, but then they're not really spending money on the training or having the right people who actually understand what they're doing. And me and I know others, I didn't come up with this term, but refer to them as button pushers, right? That they literally are taught what buttons to press and what order, and they don't actually understand why they're doing it or what each button stands for or what the underlying principles are. They just know I press this button next, or I use this cable next, which is also interesting because when they run into problems, they're not able to troubleshoot because they don't understand why the problem's occurring because it's outside their normal step process, right? Those people aren't experts, right? They're not experts, right? Anybody can be trained what buttons to press, but if you don't actually understand why you're pressing it and what the underlying basis is, that's not an expertise, right? And you'll see people who generally have this expertise are going to be able to answer questions like, well, why do you do that step next? Or what is the purpose of that, right? Or how come you don't do it this way, right? And they'll be able to explain that. Those people are generally also going to come with certifications or degrees, right? There are degrees in digital forensics. Now, you don't necessarily need a degree in digital forensics in order to be an expert in it. And you don't necessarily need certifications, right? You can have a degree, but you can't have nothing, right? You can't just have read a book. it doesn't work that way. At least I've never seen anybody who's been able to do that. In theory, there are people who are, but even people I know who because digital forensics degree is actually relatively new in terms of academia, but those people went and got certifications in the tools, right? And usually these certifications are coming through the companies that are creating the tools. There are also vendor neutral certifications, for example, the certified computer examiner certification, right? And so it doesn't necessarily have to be the company, but I would be wary of any of these certifications that are bare minimum entry level or don't require any sort of testing. Because we've also seen that somebody goes to a training, it's like, okay, well, how did they know you actually understood it or did anything? And then it's kind of a blank stare, right? And I think people really should be pushing back on this. Just because somebody is a police officer who has done dozens of search warrants does not mean they actually are qualified to be an expert in this field. And similarly, we were just talking about in terms of challenging the tools themselves, I think the ripest area to really challenge the tools are when they're using the law enforcement only tools. Because the other tools, while maybe cost prohibitive, they are commercially available. People can test them. My office can test and see if we get the same results. We can put all this information on a phone that we know what's on there and see what it pulls and what it doesn't. And we can do those tests. And there are people who've done independent and third-party tests. But the law enforcement only tools, we can't, right? I don't have access to that. And law enforcement sure as heck ain't doing it because they don't want any problems with it. And the companies have kind of restrictive terms of service with that anyway. And so when you see Celebrate Premium or Celebrate Advanced Services or Gracious Gray Key being used in your case, I think those are the ripest areas to challenge for Fry and Daubert challenges. Because just because the company saying it works doesn't mean it's true. And again, I don't think the companies are being malicious. I don't think they're intentionally building a bug or anything like that. But we have multi-billion-dollar tech companies, right? Google, Microsoft, Apple, that offer bug bounties, right? They spend $1 billion in research and trying to better their products, and people still find bugs in their product, and they pay people to let them know about it. And we're supposed to believe these digital forensic companies, which are large corporations, but nowhere near the size of Google, right? That somehow they're incapable of having flaws or errors. And as we just saw from what Signal did, and that's really how useful that is to say, no, you have flaws, right? You are not perfect. Here's an example where you weren't perfect, right? So I think really those are the best challenges to be able to offer. And I just want to mention generally how those tools are believed to work is essentially they're injecting code into the phone to disable the max password limit, right? So most phones have said that if you guess the password wrong 10 times, that your phone has been bricked, right? It erases itself, right? And that's obviously terrible for law enforcement. And so what these phones are doing is that they're preventing that, right? They're turning that off somehow with the code. And then they're doing what we call brute force hacking, which is that they then try combinations, right? And don't have to worry about the phone deleting itself because whatever code they inject. But I don't have access to that code, and I assume none of you do either. Last, I want to talk about some miscellaneous issues. So I actually saw this, there was a question in the Q&A, so hopefully this will help. How long can law enforcement hold on to a phone before getting a warrant, right? A mobile device. And there's been a couple cases. There's Mitchell in the 11th Circuit and Bogard in the 7th Circuit. But I really like this recent case at the 2nd Circuit, which found that 31 days, that waiting to get a search warrant for 31 days for a tablet was unreasonable. Of course, being a federal circuit court, they then said the good faith exception, too bad, but good for us for the future and for us in state court to be able to point to this. And they created these, they give these different factors, and no factor by itself is definitive. It's a balancing test, right? And in fact, in Smith, some of these factors actually went to the government, but overall they said on balance, it was unreasonable. And so these are the factors that we take into consideration. Now, one of those factors, which is something that is always a little problematic, is the importance of the seized property to the defendant. And one of the ways to show that is by demanding the property back. However, if nobody's gotten a search warrant for it yet, are you essentially tipping them off to that something is important here? And that really may depend on your jurisdiction. Even in New York City, where I practice, depending on which DA's office it is, they're going to get it eventually, and I'm not tipping them off to anything. Or other ones where like it may just get lost in the shuffle and nobody cares, and maybe I'm drawing attention that I don't want to draw. So that's always something to be considered. And also the longer the length of time, the delay, right? And so the longer you wait, the more it actually benefits your argument, right? That this was unreasonable. So there are strategic considerations here. And of course, always the problem of admitting it is the client's phone. I would also be very, very careful about ever saying that there is evidence on there that may clear your client. While that all may be true, and that may be great, and that may be the reason you really want to get access to the phone, you are also giving the prosecution a reason to get a search warrant. You saying that there is evidence related to the case, even though it's in your client's benefit, is on the phone, is literally something I would quote in a search warrant application. Defense counsel says there's evidence of the case on the phone, right? And so please be careful about that. Do-over search warrants. So this came up recently for us, and this Colorado case is the only one I've found that's on point on cell phones in particular. And what happened in New York was, for years, we've been making the arguments about particularity and overbreadth. And finally, right within a week of each other, two appellate courts both said, yeah, you can't just search everything for an entire, like without any date limitation or any limitations. And invalidated a lot of these pending cases, a lot of the search warrant pending cases. And all of a sudden we saw DAs just go, okay, and went and got a second search warrant, went and redid it, right? And there was really nothing on point except this Colorado case at the time. And that court said, it's a Colorado appellate court, said that as long as there's an independent source. So as long as the second search warrant didn't depend on anything that was wrongfully seized under the original search warrant, the invalid search warrant, and wasn't and you weren't prompted to get the second search warrant based on something you improperly saw under the invalid first search warrant, that this was acceptable. This raises an issue though, because unlike a house that you can't keep raiding over and over again, you can essentially do this forever on a phone, right? And there's really, how many times can they retry to get it right before a court says too many times? And that currently seems to be, they could try as many times as they want, and it's unclear. The last thing I just wanted to point out, and then I think we'll go to questions, is this case US v. Griffith, and it's not the only case that cites this, but I kind of like the language the DC Circuit Court uses, which, it's in opposition to these search warrants we see where they say, seize every electronic device because we know it related to something electronic, right? And the court says, well, these are innocuous lawful objects. They're not drugs and guns, right? You can say, go seize all the drugs because in theory, there's no reason anybody should have a brick of heroin, right? But plenty of people have phones and completely lawfully and done nothing illegal. And you can't just broadly say, seize all the devices. We want to search everything. It's just very clear.
So thank you, Harlan, Jennifer, and Jerome. I'm sure you'll agree we sort of put together some of the best minds on this issue to look at it from all aspects. We are going to go through the Q&A, but I also want to let you know that NACDL does have some of these sample motions in terms of how to challenge this, how to ask for the UFED information. I believe that will be linked to in the chat, our page on digital device searches. So we do have some information there. And I will also let you know that the Fourth Amendment Center does help people litigate these issues. So, phone consultations, materials, and at times we even assist in the litigation. So you can reach out to us at the email, the number 4ac@nacdl.org. We will put that in the chat as well. But that's what we're here for. And our litigators have deep expertise in this area. So I do want to get to the questions. There's a lot of questions. There's a lot of information, and we'll try to get through them as many as possible. I know we started a little late, so if people have time to stay on for a few extra minutes, we will try to get to all the questions. So the first question was about standardized text that could be added to discovery motions in cases, which would optimize the discovery. We did put up the link to our page, but I don't know, in particular, probably Jerome or Jennifer, if you guys have anything like that as well that you would want to share.
Not sure if anything beyond what the NACDL already has, but I'll double check.
All right. Well, you take a look at the link that we put up, and as we had mentioned earlier, if it's anything that's not in the materials, if you didn't receive them, you can email us. But also, as far as the PowerPoints go, we will request them from our presenters and put them up later with a recording of this webinar. So it will be available for you to access later on our website. I think I just dismissed a question that was the wrong one. So I apologize. If you don't hear your question asked, then I dismissed the wrong answer or the wrong question. So apologies for that. But I will move on to the next one, which is, I think you already answered that one too. How long can you hold a phone before they get a search warrant? Has been answered. Are you concerned about judges not being sufficiently educated on this technology, right? Leading them to rubber stamp simple request warrants under the false belief that they're not being intruded upon through law enforcement. So they get this request, it seems reasonable, where they say, like, yes, we have evidence that there's photographs on this phone during the month of July, and so therefore we need to search the whole phone and everything else they own. Who wants to take that one? Go ahead, Jerome.
Yes, extremely concerned. It comes up all the time. I have actually brought in live demonstrations to some of the judges if they were willing enough to actually listen and let us do it and show them basically what is actually happening here. I think this is a problem that exists beyond just cell phone searches. I think with technology in general, our judges are just not getting it. Some of them don't care. Others, I think, just legitimately don't understand it. And when all you have is the police officer, detective, and the prosecutor in front of you, who do you ask for clarification is going to give you an answer, a legitimate answer. And I think that's part of the problem. I've definitely had judges literally show me their flip phones to tell me that they had no idea what I was talking about. So Jennifer, I'm sure you've had similar experience.
I was going to try to offer a hopeful note. I think this is one of the roles that, especially at the appellate level, that the ACLU or other civil liberties organizations can play as amicus, is to do this kind of educational role. Harlan, I know, in a number of cases, Upturn has filed briefs that are educational for the court about technology and how technology works. We can, also work with other technologists. And I do know that some efforts like my former program at Stanford, the Stanford Center for Internet and Society, has Judge Stephen Smith, who's a former magistrate judge from the Southern District of Texas. And Judge Smith, one of the leaders of the magistrates' revolt, has been doing trainings for judges on issues involving electronic searches and seizures. And he did one 2 years ago, and I think he's doing another one this year. So it's a learning curve, but I think there are a lot of efforts out there to get judges to be caught up on the technology because it moves really quick.
Yeah, I just want to draw people's attention to materials that I included, which is Upturn's amicus in a case that we actually filed last month called Commonwealth v. Green, which was filed in the Pennsylvania State Supreme Court, which includes a number of arguments against like overbreadth and search warrants that aren't particular enough, that ask for basically any or all data on the phone, or any related data related to a particular offense that we believe is too broad and not particular under the Constitution.
All right, thanks all. There was a couple of questions on the signal, the vulnerability. I feel like, Jerome, you already covered that. For the person who asked, if you really don't think Jerome got it all, feel free to sort of refine your question and send it back in. But the next question is about having had clients who, the sheriff's deputy will pull them over, take their phone to the patrol car for 15, 20 minutes, bring it back, but they don't know what's happened to their phone in that time. Is it possible to do this kind of an extraction or some form of extraction in the actual patrol car?
Yes, but Harlan, maybe you want to. Yes, it is possible. A lot of these, some police departments are equipped with mobile, with data extraction tools that they in their car, or that they can bring to the scene of a crime, which is, it's interesting because one of the justifications for seizing hardware and taking it back to the police station is that they cannot get just the data or segregate data on site. So that's been one of the justifications for overseizure for many, many years. But increasingly the tools are more flexible, and it may be possible to have them be used on site, which may be a reason to challenge overseizure of hardware or of data, but also means that you have this problem where there's not a clear way for the person whose phone it is to know what's happened when the police officer's taken it back to the car.
I just think that there are in-field kits that a number of these companies will sell to law enforcement. It's kind of highly specific to the type of phone, because getting into the phone that quickly unless the person is giving the passcode could be difficult. There are also tools, for example, Magnet Outrider, which just started, which may scan for certain things very quickly. So for example, that in particular will try to find child pornography, right? And then notification that then pull the child pornography, but maybe not pull anything else. But I agree with Jennifer. It's definitely possible.
You should be able to do a motion for return of property though, even before it, or if no charges are ever filed.
And okay, so then moving on, does the software allow you to limit searches either by date or type of data or applications? Harlan, that looks like you.
Sure. Yeah, I'm happy to address that. I mean, Jerome talked a little bit about this too. Yeah. So pre-extraction, it's possible to set the, like a Celebrate, say, to copy only data within a certain date range or specify certain categories of data like text or photos. And then there's also ways that searches can be limited post-extraction, right? By specifying certain categories of data or specific keywords to be searched for. I think what's also interesting is that some of these tools now, Magnet, for example, have predictive filters where these filters try to use artificial intelligence to look for just photos of drugs or other contraband or guns. And those kinds of tools are pretty hit and miss. There's false positives and false negatives, right? It's not going to catch everything that it's trying to catch. At the same time, it's going to include a whole bunch of things that aren't of that category. And so, those are relatively new features, but that's another potential way that one could limit searches. Jerome, do you want to add anything?
No, I think what you said was correct. The only thing I will say for the pre-extraction, it's not supported on all models. So it is one of the problems with digital forensics is it's like the law sometimes. It's very a lot of times the answer is possible. And so it can be very frustrating in that way. So I think, for example, like a brand new iPhone, you may not be able to do that on, but like an older Android, you might. So it does depend. But I think post-extraction, you guys saw the screenshot that I had and that Harlan was talking about it. I think it's definitely.
And I think you can argue that the failure to use those capabilities, those functionalities to limit the exposure of the data to law enforcement to those things for which there's probable cause are overbroad searches. I think that and that can be very useful. I think one of the things that was interesting though with the predictive searching is, let's say there's that functionality, you search for something, it's drugs, but you come up with guns instead. And the question is, was that a legitimate, it was predictive, was it a legitimate search? Like, did you have probable cause to believe that that search was going to give you evidence of contraband that you had probable cause for, and you just happened to turn up other things? And to some extent, I guess it depends on how like powerful the correlation of that prediction is. If it's like, if the predictive searching is really broken and it doesn't work, and you're going to just come up with results which are not of drugs or whatever, then maybe that search itself is unreasonable. And you can't really know that without knowing more about the functionality and the functionality of the tool. And I think that's also going to be true with things like hash matching and other kinds of, for CSAM, for child abuse materials. How strong is the search? Is it a real search or not?
Okay, so I'm going to try and keep moving us through these because there's some list of really good questions. I'm going to ask two at a time this time. One, I think this might be for you, Jennifer, is a warrant question. Can the warrant itself require the destruction of non-responsive data collected during extraction? And then the second question, I'm going to just lump them together, even though they're not totally related, is can these machines actually insert data on a device? Can they plant information on the device, right? So rather than just pulling stuff off, putting stuff on.
Yeah, there's academic debate over what kinds of pre-search limitations a magistrate is authorized to impose in the warrant, for example, with destruction. But the magistrate can also just refuse to issue the warrant unless they are comfortable that it's going to be compliant, that the search will be compliant with the Fourth Amendment, and retention of non-responsive data is not permitted by the Fourth Amendment because it's non-responsive. So our position is that the magistrates can put that in the warrant, or just that the reasonableness requirement of the Fourth Amendment imposes it on the government in any case, even if the magistrate does not make it explicit. So that there's some point in time, the argument is there's some point in time at which there is a destruction, the destruction is required when it's no longer reasonable to retain that data, such as after it's been segregated or after the person's been acquitted or something like that.
All right, who wants to take on, can you insert data back on the device? Harlan, would that be you?
Or Jerome, do you want to take that one?
Or Jerome?
Sure. Yes. GrayKey actually had a product called Hide UI, which mimicked a lock screen. And so but it then was preserving the passcode. So for example, you have somebody in custody, you say, hey, do you want to make a call? You have Hide UI inserted on it, the person puts in their passcode, and now GrayKey has that program, Hide UI, has saved the passcode. GrayKey now pulls the passcode, and now the phone could be unlocked immediately. And this data exists. It's possible for other things like this to exist. I would say I think it's generally rare, but my general feeling on it is if my phone was taken by law enforcement, when I got it back, I would just consider it dead.
Okay, well, I guess the last question to that though, would there be an audit trail that would let you know that something has been put onto the phone?
In theory, possibly, yes. You could see if there was something left on the phone, but you would have to then have access to similar forensic tools to pull that. And it's not a guarantee, frankly.
All right, so the next two questions are more about the devices in the training. So is there a specific training program that law enforcement uses or certifications? And if so, what is the name? And then the other one is there like an event log that Celebrate can look for or make a report on? Basically see what was done with the phone and the order it was done, etc. So like an audit trail is how I will translate that.
I'll take the training, but Harlan and Jennifer, you want to take the audit trail? I think Harlan, you guys were working on that, right? For the training, that almost all the digital forensic companies offer their own training. Celebrate is generally considered one of the most common. They're like gold, gold standard is called CCME, Celebrate Certified Mobile Examiner. That's like a pretty real indication that the person knows what they're doing. I think in the materials I included a bunch of acronyms and the actual and little descriptions of a number of the certifications. And so hopefully that will help. Magnet also has its own, and then there's a bunch of others, but and you could even check on their websites too. They're usually not hiding that information necessarily.
And on the second question, as far as we know, there's no event log that's easily accessible. So even if you're a defense attorney like Jerome that had one of these devices, it'd be hard to know exactly what the other investigator did other than the report that it ultimately spits out in terms of what's on the phone. It'd be hard to recreate. That said, as we were previously discussing, if judges forced vendors or forced law enforcement produced these kinds of logs, I think we could potentially get vendors to start building these kinds of audit trail and audit log tools. From a technical perspective, that'd be relatively easy to do, to log basically each click and every screen and all the evidence that any particular examiner actually saw and looked at it and considered.
All right, and I think this is a critical question that I kind of know the answer to, but I'm going to ask you all. When people delete a text or image or other things from their phone, do those deleted text or images, are they still retrievable through extraction? And if so, how long are they retrievable?
Go ahead, Jerome.
No,
it's another sometimes answer, I think.
Yeah, it's sometimes it depends on the phone and the activity. So like a brand new iPhone, that's probably very unlikely the way it works. Like an older Android, you may be able to pull off everything. Part of it will depend on what other things you've been doing. Generally, the rule is the longer it's been deleted, the less likely it is that you're going to be able to recover it. But that's it's basically an impossible thing to answer because it's very fact specific.
Yeah, when you delete, it doesn't erase, it just makes the space where the information was stored available for something else to go there. And if nothing else goes there, then the thing you deleted is still there.
But
Yeah,
the one thing with like some of the newer phones, for example, is iPhone is actually encrypting it before it actually deletes it. And so even if you recover it, you may not actually be able to do anything with it, which is why like even Celebrate's not really pulling deleted information from an iPhone brand new iPhones anymore. But yes.
and the other thing I'll just say, if you probably don't remember, but at the beginning when Jerome put up the screen of like, what does it look like, the extraction log look like? There was, it would say photos, there was a number, and then there was in parentheses in red, another number. And that parentheses in red, which he's about to share again, those are the deleted files that it found. So just sort of what does that mean when you look at it? That's where your deleted files are. Again, whether they're encrypted, whether you could open it, whether you can find it is a different question, but that's what those look like. And so a question that I think any of you can answer, what do you recommend as best practices for individuals to protect their devices against government overreach in terms of these searches and seizures? Is it passcodes? Is it cloud storage? Is it encrypted apps? Is it don't carry your phone anywhere, which nobody will do? What would the answer be?
That's like a whole, like.
That's a whole nother webinar.
Yeah, but the quickest, easiest one to give you is use a 6+ character alphanumeric passcode. Especially if you have a newer phone, it'll be a lot harder to brute force hack.
Yeah, and the answer is if you go in to sort of change that, you will notice, like at least in the older phones, you had like the number of boxes. It would show 4 boxes or 6 boxes, which indicates clearly that's how many numbers are in there. But you can change it to where it's just a rectangle. So it is not clear like how many numbers, whether it's alphanumeric or numeric. It makes it harder to get into the phone. It doesn't mean these devices will never get into your phone, but it can take them a lot longer. So, police will have to really commit if they're trying to get that information versus, a 4-digit number passcode.
Yeah. And not just 6+ digits, 6+ digits and random, right? Don't use your dog's name or any other English word because those are really relatively easy to brute force. Try to use.
So not fluffy. Got it. I know we are a little bit past time as we started a little late. We do need to put up the CLE code again so everybody can have that. So there it is again. I will say, please write it down. You do need this to get your credits. 7H, like Harry, 7432. So 7H7432. Guess I'd keep it. You've been here. You want the credit. We want to give it to you. You can't get the credit without it. So as far as questions go, I'm going to get back into these. Sorry, I've moved my questions over. I can't read them all now. What's the most secure cell phone for privacy conscious people? So what's clear is, as much as there's a lot of grousing about the people who go dark in the cell phones, no one can get into, even when they claim that, they always seem to find a way. And there's been sort of this race between the tech companies who are trying to make these phones, who want them to be secure because that is in fact a selling point, and then the tech companies that are trying to break into these phones. And so the phone companies will say like, well, now we have this phone that has these protections, and then the other companies will say, well, now we've figured out how to crack into those phones. And so I think it's like a constant horse race where everybody keeps getting a nose up, but there's no straight answer. I think ultimately, for the most part, they can get into almost any phone. And I think if you found the phone that they could not get into, then the company would come along that would figure out how to get into that phone, right? So I guess that would be my answer to it. And that's why nobody wants to answer as an endorsement of which phone to go and get. There's a question about the deleted files. Can you tell when the text or photos were deleted? Like, is it possible that they could tell that, the photos were on your phone until you're sitting in the car and you're pulled over and you start furiously deleting? Will they know that they were just deleted, in the 5 minutes before the phone was seized? Or does it just show as deleted? It could have been deleted anytime.
Sometimes you can. Sometimes, because a lot of times, even when they're recovering deleted files, it's sometimes only recovering parts of it. So like, there's been situations where I've seen a message recover, but what the message said isn't recovered. So I just know that there was a message at this date and time. So it really does depend. I will say that it is becoming less common that deleted information is being pulled, as I think the way the phones are deleting stuff has become more sophisticated.
Okay, and so now we're going to go to motions to suppress. When you're arguing a motion to suppress on electronic evidence, aside from going after the seizure itself and without specific facts, what are the strongest areas to attack? Jennifer, I don't know if you want to take that one.
Aside from
attacking the seizure itself. So aside from they shouldn't have taken the phone.
So I think the question then is about what the search was and whether the search was cabined to probable cause. And that can be, I think, both about the extraction of data and presentation of it to the investigator, and then the way that the investigator queried the data. So you have the seizure and then you have the search, and was the search conducted in a fashion where the queries and the information were the production of the information was cabined to that for which there was probable cause or not, or cabined to the purpose or the scope of consent if it's a consent-based search. So given the tool's capabilities, that could be based on time frame, that could be based on who was in the conversation, that could be based on categories of data, like is it images versus credit card transactions or emails or something like that. So looking to see whether that whether they followed along with what the probable cause really was.
All right. So if they say we need everything on your phone because we have evidence that there was text messages between these two people, that's sort of the easy entry to say you shouldn't be looking at anything other than text messages between these two people.
Yeah. I mean, often we're seeing this as a problem in the warrant itself, right? So number one is the warrant. First of all, you'll see warrants that are like, we should be able to seize the phone because drug dealers keep evidence on their phones.
Yeah.
Super broad. We should be able to search everything on the phone because this drug dealer was talking to the supplier on this date. That's too broad, right? You should search for what the drug dealer was saying to the supplier on this date, but instead you searched for far more than that, and the police looked at all the text messages. That's wrong, so all there's many ways, all of that is a way to go wrong. And I should just say, I think these forensic tools actually touch all the data on the phone. They technically search all the data on the phone, but one of the real questions is what do the police eventually see? It's still a search, I think, of all the data, but it is still a search of all the data, but it is unreasonable for the cert tool to be used in a way such that it surfaces and makes visible information that's not responsive to probable cause. At any step along the way.
So here's a different kind of question. If your client is actually a witness, but their cell phone was seized by law enforcement, does the attorney have the right to insert some kind of forensic search restrictions to their client's cell phone? Or do they have the right to search the phone would be my question. But
for the witness's phone?
Mm-hmm.
So this is actually a big deal. In the case I mentioned that we did in the Wisconsin Supreme Court at Birch, one of the amicus briefs on behalf of the defendant came from a crime victims organization. And they talked about how people who are victims of crimes like domestic violence are often having police overseize their phone data and not treat it in a way that's respectful of their privacy or their scope of consent, given their role as victims and being vulnerable people. And it is true that the defense attorneys in those cases get access to the victims' information, and courts have not been issuing limitations on the way that either defense attorneys or prosecutors have been using data from victims' phones that has been turned over pursuant to consent, but under also some very emotionally, volatile and stressful situations. So for information about that, I think looking at that brief in the Birch case would be really interesting.
All right, Harlan, I think this may be for you, but a question about, and I don't know, forgive me, because it's been a minute since I read the report, but this is something that came out in your research about which state police departments or even local law enforcement departments supply extraction devices that are carried around in vehicles. Because this person not heard of it before today, did you guys get a sense of how frequent that is, or which departments? I mean, you have the departments that use them, but I don't know if you got into that granular level of, have it at the police station versus in the car.
Yeah, we didn't get to that level of granularity. Most of our data that allows us to say that, state law enforcement agencies in all 50 states use these tools are mostly from purchase records, right? So, we can see that they paid Celebrite, a certain amount of money, sometimes for the specific line items. But we can't necessarily tell, how many of them have them in their, squad vehicles and how broadly they're deployed, or whether they just have a few in the office. So that level of granularity that we weren't able to figure out. But perhaps more specific and further FOIA requests to your particular state law enforcement agencies could surface that information.
All right, who doesn't love a good public records request? So there's a question on sort of biometrics and phones. It's more of a compelled decryption question, but what about when the police just hold the phone up to your face, or maybe put your fingerprint on the phone before an extraction? I will say, if you go to the link that Wendy had posted earlier on our digital device page, we have a compelled decryption primer that addresses some of those questions, but does someone want to take that on?
So I think the argument's a lot harder than compelling somebody to put in their passcode, because generally the argument is you don't really have a reasonable expectation of privacy in your face, and they're not compelling you to do anything similar to taking fingerprints. There was a case, I think it was the Southern District of California, where a district court judge did find fingerprint that they couldn't compel the person to give a fingerprint. But I think most courts have not followed that. I think it's a lot more contentious, and there's a lot more disagreement across the country over whether or not or when a court can compel you to give a passcode. So I always encourage people to use passcodes and not to use biometrics. There's also a secondary security thing, which doesn't come up much, but it's true, is if your passcode ever leaks, you can change your passcode. You can't change your fingerprint, you can't change your face, right? It's similar to like DNA, really, so to use something that you can't change, I'm personally, I think it's a bad idea.
All right, and Wendy did drop the primer, the link to our compelled decryption primer in the chat. So that has a good amount of that information. And again, you can also email us at 4ac@nacdl.org. We love to help.
We have a petition for cert before the Supreme Court now on a case out of New Jersey on the compelled decryption issue with regard to passcodes, not biometrics. The answer with biometrics is don't use them.
That's the short answer.
Sorry.
So there's a question about factory reset on the phone. Does that permanently delete the data on the phone so that Celebrite can't get it? Or will there still be remnants of whatever was on there even with a factory reset? Assuming
that there was nothing going on your phone ahead of time, like there was something inserted ahead of time, and that it's a phone where encryption was enabled, not like old Android burner phone. In theory, it should not be recoverable. But the data that's being deleted in that situation should in theory not be recoverable.
All right, this is actually a follow-up to the biometric question, but if there is a phone which somebody uses, their face to unlock the phone, can a picture unlock the phone?
No, that shouldn't be possible.
Okay, you need the actual face. So I'm sorry, they keep popping up, so I'm having trouble keeping track. So have judges issued orders under the Stored Communications Act versus a warrant in terms of phone extractions? Has anybody heard of, I'm not sure how that would quite go, but.
The only way I would see that happening is if they were trying to get the cloud backup, right? So if you wanted somebody's iCloud backup from Apple, they can get a search warrant under the Stored Communications Act. And this is very important for everybody. Your backups to iCloud and Google Drive are not encrypted, and Apple and Google will comply with the search warrant. So be aware of that. But to get into the physical phone itself, I don't think the Stored Communications Act will apply.
So I think if I can at this point, maybe just give everybody a minute to wrap if they have something they want to say. We may post the code one more time and then we're going to wrap up. But this will be, like I said, up on our website in the coming days. And appreciate all the attention to this issue and all the people who came to attend. Do you guys want to sort of give a quick wrap? We start with Jerome, maybe where we started.
So thank you, everybody. Really great questions. Please feel free to reach out to me if there's anything I can help with. Although, as Jumana has mentioned, the NACDL has a great Fourth Amendment Center and doing great work, and I'm sure they can help you with a lot of this stuff too. I think I've talked enough for one day, so I'll pass it on.
Harlan?
Yeah, similarly, folks should feel free to reach out to us. When we feel like we have the expertise to weigh in, we're willing and happy to write amicus briefs on this topic. And also, if there's any other detail that you all think would be helpful, we're happy to, give talks or, do a webinar for a larger staff if this kind of material would be helpful to folks that you all work with.
Jennifer?
Thanks. Much of my work at the ACLU right now deals with this issue of warrants for electronic information, what the scope of the warrant is, how the warrant is executed, and how and what data is seized as a result, and how the search is actually conducted, and what that means, what's required under the Fourth Amendment for that to be reasonable, as opposed to be this bonanza of information for law enforcement. So if you have cases that deal with any of these issues, and you want amicus support or even just sample briefs or something like that, and the NACDL website, which is great on this, doesn't offer what you want, or you want a little more information, or you want to know if the ACLU is interested, please reach out. I did put my email address in the chat. So thank you. And thanks to you, Jumana, for organizing this, and for all your people. I love getting a chance to do these for NACDL because this is such a great organization. When I was a criminal defense lawyer, I was so grateful to be a member and for the support. So thank you.
So thank you to all of our guests. I will say, this was obviously free and accessible to everybody, but if you're not a member, you'd like to become a member, you can always join at nacdl.org/join. There's a lot of benefits to being members, including the ability to just write on the listserv and ask questions of other members and do brainstorming, lots of programming, lots of other good material. Koichi, I don't know if we're going to put up the CLE code one more time, 7H7432. Thank you again for joining us. Thank you for staying on, and we look forward to doing more trainings with you.